Just want to make sure that we are live, and then we'll actually get this shit show going. So let's see. All right. All right. So people should be hearing you now. Say something, son of a bitch.
Hi, everybody. Greetings, programs. I like Tron. I'm sorry.
Let's see. I saw Red's voice, and now I'm blind. God. Tell me about it. Sound is light. Light is sound, apparently. Anyway, let's get this set up here. So, OPTLawyer, how's it going, good sir? Why don't you introduce yourself to all the cool peeps, bitches, and hoes that are in the live chat.
Well, hi, everybody. I'm OPTLawyer, and I apparently play a lot of video games and don't take anything seriously.
Neat. But by the way, we want to be clear that none of this shit is legal advice.
Yes, I am not anybody's attorney. This is for entertainment purposes only. I will probably be saying that every 30, 40 minutes, whatever.
We are not your lawyer.
No, I'm not.
You need to pay for that shit. And by the way, you could probably do better.
Not wrong. Besides, if you needed my legal services, you were already convicted and in prison because I was your appellate attorney. So if you need my legal services, you're already in deep trouble. So
you're kind of in some deep shit, bro.
Yeah, you got just a bit.
Oh, just so much manure. So anyway, you wanna tell people why we're here today?
Well, I'm here because you asked me to show up. I don't know. No. All I got is a message for you saying, "Yo, what do you want to do a hangout?" I'm like, okay. Apparently, we're going to go through the stuff that Steve's lawyer has filed in the lawsuit of McRae versus Curtis.
Ah, interesting. By the way, for those of you who don't know how this really went down, it was like, hey, you want to do a hangout? And then he goes, well, you see, I can't because I'm kind of busy that night. I have prior engagements with, the family, the significant other. I got things I got to do, and I was like, okay. So hangout starts at 9:30. Yeah, I'll see you there.
Right. No. Yeah. No. Everything I was going to do canceled. Like, well, I guess I could go on Red's channel.
Thanks for having such poor standards.
No problem, man. No problem at all. Happy to be here. Honestly, I was thinking, I stream a little bit here and there, but really after this, I could just shut my channel down. I'm never going to top this.
Oh, you're too kind. Thank you very much for having, again, such poor standards.
No problem, man.
Okay, so basically what we're going to do here is I'm going to screen share for you, and then we will just read this out. So the first thing we're going to do is we're going to read, I guess, a thing that Kyle sent, which is kind of hilarious because, it's hilarious for a great number of reasons. Let's be fucking honest here. But apparently, this document misnames Steve's lawyer. I don't think the name of the lawyer is Brown. So it's like highlighted. CC Scott Brown. There is no Scott Brown, you dumbass. So
I'm sorry, I didn't even realize that he got that. Okay, well, that's great. It's a good way to start. Misspell and get the lawyer's name wrong.
So let's go ahead and do this. So I have it screen shared right now. It's probably not going to come through on stream all that well, but we'll just do the best we can with what we got. Okay, so it says, RE motion to set aside case with prejudice. And
yeah. So can we just stop immediately on that?
Okay. We're literally 2 seconds in, and we've already hit a speed bump.
Okay, so with prejudice, that's how you dismiss something. You don't set aside a case with prejudice. It's a dismissal with prejudice means your case is done, it's over, and you can never bring it up again. A dismissal without prejudice means you might be able to refile it under certain circumstances, normally within 1 year. So there's no such thing as setting aside something with prejudice. You just want to stay in to set aside the default judgment. That's sorry.
Does it sound like that there's actually a lawyer typing this, or does this sound like ramblings from a guy who's obviously not a lawyer?
What it sounds like is that somebody, either Kyle himself has done a bunch of internet searching and put a lot of stuff together and just kind of threw it into a blender and regurgitated onto a piece of paper, or somebody gave him a whole bunch of legal terms to use and he just decided to throw that into this.
It's a case of just fling everything at the wall and hope something sticks.
Yeah, or worse than that, it's just a matter of throwing words into paper and praying some of it makes sense.
Word salad. Yum.
Basically, yes.
It is so delicious and scrumptious.
Right?
So let's see. Dear Sir, okay. I request to motion the court. I don't know if that's proper.
No,
termage.
But that's not the thing that's killing me here, but yes, go ahead.
Okay. I request to motion the court to set aside case with prejudice and a stay on all proceedings until this motion is addressed.
Okay, so that is redundant upon redundancy. I mean, you
have the floor here.
Okay, so like, you file a motion to set aside default judgment. Okay, get that. Absolutely. You want to stay all proceedings. Well, okay, so there's no proceedings yet because they haven't actually gotten a monetary judgment yet. If Steve had a monetary judgment, then yeah, we'd be looking at. I know. I've heard North Carolina's not a garnishment state-ish, but you can attach that judgment to things and whatnot. Okay, then you might want to stay those things. But you don't. There's nothing.
I need you to calm the calamity that is your memories.
Red, it hurts my soul. Okay?
I need you to breathe. I need you to breathe. Okay, I need you to bring in through the nose, out the ass. In through the nose, out the ass. Okay, so now with that done, let's continue.
I have achieved a state of calm.
I also ask that the court to have the above referenced case and default judgment immediately set aside with prejudice and a stay on all proceedings until this motion is addressed. The law requires that the summons and complaint be delivered to my primary address or dwelling if using certified mail. And then it says the plaintiff knowingly used an old address to improperly serve me the complaint and summons. Yeah. Really? That's what happened.
Yeah, I'm sure that's what we'll get into that later. Clearly.
Yeah. This is where that's something that Steve's lawyer will have a lot to
also
talk
can
about.
I point out just this is written as a letter?
I'm guessing.
No, it is. It says, "Dear Sir." It's written as a letter. I'm not. Okay. You file things. You don't send them to the judge in the form of a letter. I don't know.
Judge, I typed up a letter with a whole bunch of legalese talk so it appeases your eyes.
Yeah, basically. That's kind of what it looks like.
The plaintiff, Steve McRae, admits to using my old address in an effort to use the court system to his own ends. As evidence of this wrongdoing by the plaintiff, I have included the plaintiff's admissions on video. The plaintiff says he knew I moved and sent the paperwork to the wrong address on purpose.
Mm-hmm. Yeah. Interesting thing about that we'll touch on in a little bit, too. Actually, it's something I literally just noticed before we went on air.
What's that?
Oh, the date when he says he moved out is the same. Happens to be the exact same date that the certified mail was signed for.
Neato. The plaintiff says, I'm sorry, hang on. Into the nose,
right?
Out
Yeah.
the ass. Into the nose, out the ass. Okay.
Mm-hmm.
The plaintiff says this on his YouTube channel to thousands of people, making a mockery of our legal system.
Okay, so just
Yeah,
I want to throw this out there.
he's the one making a mockery of the legal system.
Okay, yeah, there's
Cool.
that. Making a mockery, quote unquote, of the legal system is a little hard to do when all you're talking about is service of a lawsuit. Like, jeez, dude, seriously. Okay, I mean, like, I don't understand the dramatics of this. I just don't. It doesn't make your thing. I'm not even going to call this emotion. It doesn't make your thing look any better.
I have provided the recording to the court and links the plaintiff's video and admission here. Copy and paste YouTube link.
Okay, so one thing about that, if you're gonna send the court a video, you probably want to send it to them on like a DVD, CD, some media that isn't just some random link that they have no clue where it's gonna go.
Oh, here's a YouTube video. Watch my shit. There you go. I win.
Yeah.
I did a law. I did a law just now.
Yeah, or yeah, it's especially with like the potential of virus attacks and whatnot. A county employee is not just going to randomly pull up a link that some person just randomly sent, like the judge or the court.
Let's see. So I have provided the recording to the court and links to the plaintiff's video and admission here. I will be calling the plaintiff himself as a witness in an evidentiary hearing.
Okay, so I mean, I guess technically the court could have had a evidentiary hearing on the issue, but it's a service issue. There's not much in the way of evidence you need outside of affidavits and actual evidence of not being present or something to counteract the fact that you have a signed certificate of service where you happen to say you lived.
Does this guy really think the judge is going to take this shit seriously? It's like, hey, about this letter that you sent, can I ask what the fuck? Before you answer, just know I don't give a fuck.
I mean, then there's so there's that. I mean, in all likelihood, the judge will either just rail him for it, be like, what in the world are you doing here? Or he's just going to basically be like, this is nonsense, I'm ignoring it, I don't care. I mean, it's going to be one of those things. He's either going to call him out on it, or he's just going to be like, you know what, this is nothing, this is a pile of nonsense, and forget it.
Also, are you ready to laugh?
I've kind of been the whole time, so...
Okay, here we go.
Sure.
At this time, there is no controversy about whether the service was improper. There is no controversy. God damn it.
Okay,
about whether the service was improper.
Yeah, okay. So, as if you haven't actually watched the video, those of you out there, I did, in fact, go watch it real quick. It's a very small snippet of a video that I'm pretty sure is taken out of context.
It is. It really is. So the judge is going to look at that and go, listen, Kyle, before you answer, just know I don't give a fuck. JK, I give so many fucks. Hey, Curtis, inside the bag is all the fucks I give. Kyle opens bag. It's empty. Oh, no, I'll just run over to the fuck store. It's open till 8. Oh, no, it's 8:02. Oh, look, a vending machine. And there's one fuck left. Puts dollar in vending machine. Oh, no. The fuck got stuck. The plaintiff admits it was not on video. In all caps, by the way.
Plaintiff admits it was not on... Okay. Plaintiff admits it was not... I don't even know what that means.
I think he's like... At this time...
okay, you know what? No, there's supposed to be a comma there, I think.
Yeah.
But the plaintiff admits it was not, as in the service was not proper on video. That he admits on video it was not proper.
Yeah,
okay.
there's a missing comma there.
something.
Admits it was not on video. What's not on video?
Yeah, like sentence structure, bro. Seriously.
Shit. At this time, there is no controversy about whether the service was improper. Yeah, bullshit. The plaintiff admits it was not on video. The plaintiff's admission and the evidence provided make it clear that this judgment should be set aside in the interest of justice.
I mean, okay, so that is like one of the tenets of most of the rules of civil procedure. So that line by itself is not offensive in so much as that he's used it. The fact that he's phrased it in such a way is still funny.
It's like, oh, in the interest of justice, yes. In the interest of justice, let me just completely get away with the fact that I royally fucked somebody out of thousands of dollars and fucked them out of a YouTube channel that they helped create that I was a 50% partner on. What the fuck, guy?
Does he still demand 50% of the thing? Is that
I have no idea. I can only assume he's trying to get something positive out of this. He's trying to have some kind of victory, and anything will do. Even if, at this point, he's just going to get a participation trophy, but whatever.
We call that a judgment entry.
The plaintiff has lied to the court and served the wrong address to deprive me of my day in court.
Okay, so if we want to deprive somebody of their day in court, one of the biggest things you probably shouldn't do is respond to an order from the court before filing your motion to set aside default.
Yeah, by the way, what was that? What was that one audio clip that we kept playing? The one where he do we have an audio clip of Kyle admitting that he was served?
Oh yeah,
I think so. So Steve McRae went through all this back channel way of doing things to deprive you of your day of court, but yet all of a sudden we have.
Oh, I had to. What I did was in the original papers that I was served.
Wait a minute, what was that?
Papers that I was served.
I'm sorry, I didn't hear you. Can we hear that again?
Papers that I was served. Papers that I was served. Papers that I was served. Papers that I was served.
Interesting. Kyle Curtis, 2019.
Yeah.
Dude, the only person that deprived you of your day in court was you, by the way. By the way, did you know that he did an interview with some other jackass that we know, unfortunately, where he said that the reason why he didn't go to court was because he wasn't in the right headspace? By the way, that shit's been downloaded.
Nice. In the right headspace. Yeah. That's why you don't go to court when you're sued, is if you're not in the right headspace. Absolutely. Actually, it probably was the best thing he ever did as far as admitting everything, because that's basically what happened.
Yeah.
Especially at the moment.
I ask this court. I ask that this court case be dismissed with prejudice.
They say, okay, there it is.
To warn others who want to deceive the court system and violate others' rights.
Okay, so there's a thing. Let's pretend, and I'm just hypothetically speaking, that Kyle wasn't actually served, and we had no evidence of it whatsoever. Let's just hypothetically speaking here. I know I'm going way out in fiction land here, but if he was correct, all that would do is remove the default judgment and put the case back to in a posture of discovery and then trial. You can't have a dismissal based solely on a service issue. I mean, like a service issue like this. You know, you get default judgment, it comes back and says, hey, I was never served. Okay, great. Now you know about the lawsuit, so we'll just undo this and, Control Z the default judgment, and now we're back.
Control C.
Exactly.
Control
that's
V.
all we do. Yeah, that's all we do. That's all it would do. There is no dismissing the case right now. It doesn't, that is not a thing that would just happen.
That's not how this works? That's
Not
not
normally,
how any
no.
of this works?
No.
God damn. That's fucking hilarious.
Not at this point, no.
Oh, God. Well, here we have more stuff to read. But anyway, that was funny, wasn't it? So, let's see. Let's see. I am going to skip ahead to this document right here. Let's see. Okay, so let's go through this. Now, this is all legalese. I hate legalese, just as a point of fact here. Mm-hmm. So let me just get this going. Public access. Okay, so you should be seeing the screen right now.
Yep. Well, I am. I don't know if it's on.
Oh, no. I'm going to be showing it on the main.
Oh, okay.
Okay, so there we go. We're going to be showing this shit on the main. Like I said, the words are going to be very tiny on the live feed, and I apologize for that, but is what it is. So anyway, plaintiff Steve McRae, through his undersigned counsel, blah, 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 submits this response in opposition to defendant's motion to set aside default judgment. Now, right there, that sounds like actual lawyer talk.
Yeah, shocking.
It's amazing. It's almost like Steve actually has one of those. Oh, I'm sorry. You want to say something about that? No.
I just said, yeah, like this. Here's a person who actually, like, one, practices in this area clearly, and two, has an idea of what he's doing and does it very well. You'll see.
Let's see. I don't know if this is a 1 or an I. I'm going to assume it's a 1.
It's actually, well, it's a Roman numeral 1, so it's an I.
Okay, so I. Matter before the court. Plaintiff Stephen McRae and defendant Kyle Curtis had a partnership whereby they agreed to create and co-host a podcast, which eventually came to be known as the Non-Sequitur Show. Rather than abide by the parties' agreement concerning the business, defendant Curtis took control of the show and denied access to Mr. McRae. Mr. McRae filed this lawsuit to enforce his rights and served Mr. Curtis by certified mail at the address he had used for the business and for the show. Which, by the way, what was that? What was that? That audio recording that we just heard in the papers that he was served?
I believe he said he was served. Yeah. Yeah. Just so what the lawyer is clearly saying here is that Kyle held that out as his address where he gets stuff. Mm-hmm. It's kind of important to this entire process here.
So the certified mail receipts were returned signed, and Miss McRae filed an affidavit of service. Basically, that means I do swear that it's this shit's real.
Well, an affidavit of service is. Yeah.
It actually happened. I'm not bullshitting you, that kind of thing. Okay.
Yeah, pretty much.
Mr. Curtis failed to respond to the complaint, and his default was entered by court on October 3rd, 2019. The court further entered partial judgment by default on January 23rd, 2020.
Mm-hmm.
Defendant Curtis now claims that his address they represented to be his, and to which numerous items were sent without being returned undeliverable, was incorrect. He provides no evidence for this contention other than an affidavit stating that he moved in July of 2019 and various other items of unsworn hearsay.
Yeah, it'll come up later, but that, by the way, that affidavit where he says he moved in July of 2019, oddly enough, he then files a different affidavit later that changes the date.
So he's making shit up.
Probably. Now, something like that, if it was that by itself, say that was the only issue, I mean, there's a lot of them. Let's say that was the only issue. You could easily say, you know what, mistaken date, whatever. Okay, no biggie. But take that with everything else, and I really got to question what's going on here.
Yeah, tell me. As argued below, Mr. Curtis clearly had notice of, next page, complaint and opportunity to respond. His last attempt to escape the effects of his default are unavailing. So
God, I love that line.
So would you like to explain what they're saying with that line?
Well, basically, all the That's great. It's a great line. It's trying to say, one, Kyle is now trying to do something like long after the fact, and it's almost too late. And then two, his efforts, his attempt is unavailing. Is basically, your argument is complete and total bunk.
So this is his attempt to escape. Basically, look, he's trying to get off scot-free. Is essentially what they're saying.
But yeah,
he's trying to get off scot-free. He's trying to not have to deal with the consequences of his actions of screwing over Steve McRae. But tis what it is, I guess. So 2 eyes now. We've made it to 2 eyes. Don't you feel accomplished?
Oh yeah, no, absolutely. This is easy to get through.
Statement of relevant facts. A. History of correspondence to and service of process on defendant. The complaint in this matter was filed and the summons issued on August 23rd, 2019. The summons and complaint were served by certified mail. Return receipts requested, addressed to the defendant Kyle Curtis at... do we need a... I'm not going to say the address, fuck it. It's not really needed. The United States Postal Service electronic tracking system indicated that the summons and complaint were served on August 30th, 2019.
Okay, keep that date in mind.
Okay, we'll keep that date in mind. Now, when it says the United States Postal Service electronic tracking system indicated that summons and complaint were served on, it was served, that means that there was a signature on it. They actually have a picture of the signature, which appears to be Kyle's mom.
Well, not just that, but the electronic tracking system also means, you could pull up the tracking number on the website and then just be like, oh, hey, look, here's all the steps that this thing took to get to your place.
Yes, it's like, hey, yo, it's all documented. It got there. See that little green check mark? The little green check mark means it's there. It means
right,
it got there. It got to the address that it was addressed to. Yeah. So that's what that little check mark means. The little check mark means, yo, I did my shit. I did my job. I did it right. I did it properly. You got the letter. Slim Shady for president, y'all. That's pretty much how it goes. I think. That's legal speak right there.
Yeah, sure. It is totally.
Since you're a lawyer, you know what I'm saying.
Yeah, 100%. Absolutely. Totally understand what you totally. Yep.
Okay. The returned receipt shows a signature appearing to be Suzanne Curtis, dated August 30th, 2018. So
I'm thinking that's a typo.
A typo?
2018.
Oh yeah, it is a typo. Look at that. Steve, fix your shit.
That happens. Yeah, it's whatever.
Okay, so we know it's August 30th, 2019 is what they mean. And so that means that there was an electronic tracking system that indicated that I actually got there. There is a signature appearing to be that of Suzanne Curtis, and that was on the same date. All right. So let's see. The city, we're not going to mention. Address, so let's just say the address. The address was the one used by Mr. Curtis during his dealings with Mr. McRae. For example, Mr. Curtis prepared a fictitious business name statement for filing in California and listed his address, the one that we're omitting. In addition, in email correspondence for the Non-Sequitur show, Mr. Curtis lists the address that we're omitting as his address. Property records show that address is now owned and has been owned by Claude and Suzanne Curtis, which would probably be his parents.
I would assume, yes.
Yeah, who are presumably related to defendant Kyle Curtis. I fucking hope so.
I would hope. That'd be a very weird situation if they weren't. Just saying.
It's like no, it's total coincidence that we all happen to share the same last name and just happen to have been living in the same address.
Just saying, yeah.
Yes. Totally fucking. I mean,
anything's possible, Reds. Anything's possible.
I mean, what are the chances of winning the lottery? And people win the lottery all the time. So
right, exactly.
I mean, whatever. Okay. Attached as Exhibit A is a true and accurate printout from the property record showing that the address has been owned by Claude and Suzanne Curtis since 1990. So they've owned this place before I was even born.
Okay, you just made me feel really old right there. Just saying.
1991, bitches.
81 myself. So, there. You see, so here's the way that you properly state I'm attaching something to this motion. The Exhibit A is a true and accurate printout. That means, number one, I'm not attaching the original because maybe an original doesn't even exist because it's an electronic printout. But the thing I am attaching is a true and accurate copy of the thing that I could print out from online.
All right. So, and that needs to be specified in the document, I assume.
Well, I mean, it's one of those things that is assumed a lot of the times, but because we're lawyers, we actually like to make sure the court understands that we are certifying the fact that this is a true and accurate copy.
Ah, okay, all right. So let's see. The summons and complaint were not the only items sent to the address that we're omitting. On January 17th, 2019, counsel for Mr. McRae mailed a letter to that address with electronic copies to email addresses known to be used by Mr. Curtis. A copy of that letter is attached as Exhibit B. So what they're saying here is that not only did we mail the letter, we also emailed it to email addresses, so as in more than one.
And no. I have to assume because the Steve's lawyer is putting this in there, North Carolina must allow for electronic service like that.
Yeah. So basically, I think what they're trying to do is that they're trying to show that they were doing their part in the service. Oh, yeah. Not only did we file for through an actual letter, certified mail with a signature, which was signed, but we also bombarded the ever-living shit of not one but multiple emails used by Mr. Curtis.
Yeah.
And a copy of that is attached as Exhibit B, blah, 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 blah. So let's see. Counsel for Mr. McRae. Sorry, counsel for Mr. McRae.
Yeah.
Yes. On
Yep.
I think I said that. I may have missed it. So let me just repeat. On July 17, 2019, counsel for Mr. McRae mailed a letter to that address with electronic copies to email addresses known to be used by Mr. Curtis. A copy of that letter is attached as Exhibit B. Okay, now that we got that out of the way, the next bullet point is, on August 29, 2019, a notice to preserve data was sent to the same address and email addresses. A copy of that letter is attached as Exhibit C. Ah, yes, that one. That didn't... tell me, does the Non-Sequitur Twitter still exist?
According to what everybody has told me, no.
Yeah, because it looks like he decided to say, oh, notice to preserve data? Fuck that!
Yeah.
Oh, God. It's...
Yeah, I don't... That's a thing.
Oh, God, that's... Okay. An affidavit of service of process and a motion for entry of default were both mailed to the address that we're omitting on October 2nd, 2019. And a motion for default judgment, ECF number 10, I assume that stands for electronic court filing?
I'm assuming yes, actually.
I'm okay, let's assume that's what it is. I will stand corrected if someone corrects me on that.
Yeah, it would be in North Carolina, or even that court thing specifically, but electronic court filing would make the most sense. So
all right, so the motion for a default judgment, ECF number 10 in parentheses, and the renewed motion for default judgment, ECF number 14 in parentheses, were mailed to the address that we are omitting. Upon information and belief, the court mailed the order on renewed motion for default judgment to the address that we're omitting, ECF number 16, weird fucking symbol 11.
That's paragraph.
Okay.
So the phrase "upon information and belief" is something you actually see a lot in complaints and things along these lines, because what that is telling the court is the lawyer or the party has a very based on information that they know, they may not have first-hand information that because they didn't do it. They're not the ones who said it. The court said it because that's what the court is supposed to do.
Yes.
My guess is that there's an entry someplace saying it was done. So because the lawyer didn't do it himself, he'll say, upon information and belief, the court has done this because everything I have says the court did it. So I have to assume it happened.
Yes. All right. So the upon information and belief one. Okay.
Mm-hmm.
A copy of the court's entry of partial judgment by default, ECF number 17, was sent certified mail to the address that we're omitting on January 27th, 2020. A copy of the letter enclosing the judgment and a true and accurate copy of the certified mail return receipt is attached as Exhibit D. Now, why are they going into such exquisite detail here?
Okay, so, I mean, Kyle's saying I didn't get service. Well, here's all of the things that we've sent to you prior to your, prior to you filing your motion to set aside default. Not to mention the fact that they're also showing, not only did we serve the complaint on you, we served the motion for default judgment on you. That means that we told you you were going to be in default if you did not respond.
I also remember talking to Steve McRae about this, but he messaged me while I was sitting down for dinner one time saying, hey, the court is going to give him an extra amount of days so that he could bring something up. And that extra amount of days to give him, more time was given to him. In that time, he had multiple streams talking about the case.
Mm-hmm.
So, wow.
Yeah, court doesn't like it when you play games, just saying.
Yeah. Oh, yeah. By the way, before we actually continue, I want your opinion on this.
Okay.
The court doesn't like to play games. You just said that. What do you mean by that? Like, what is the core of what you're trying to say there?
So, hypothetically speaking, because, I don't have complete evidence of this, I have a very good hunch, but if somebody got a lawsuit and it decided to ignore it and go tell everybody that he got paper served and, oh, I have a lawyer, and I don't really have a lawyer, but I have a lawyer, and I'm going to respond and tell people he's filed things and whatnot. And then the court's like, yeah, you're in default. And then he comes up and says, oh, but wait, no, I'm not. But the other side has evidence where he says something along the lines of, oh, I just was waiting back to see what was going to happen with the lawsuit before I responded. Okay, so clearly, number one, you've kind of indicated that you've decided to waste everybody's time.
Yeah, no shit.
And that is pretty much a stall tactic. And you decided to, completely ignore the system until beyond the last possible moment. We gave you the last possible moment, and you still ignored us. It wasn't until I started issuing orders that you have to do stuff that you decided, hey, wait a minute, I don't want to do that.
Hey, I have a button right next to me. Let me press and see what happens. Hang on. Gamesmanship. Whoa, that was weird. Let's press that again. Gamesmanship. Hey, I wonder. Good. Gamesmanship.
See, I told you I'm never going to top this. This is great. I love this.
We're having fun here. We're having a good. This is quality time we're spending together. We're spending quality time together.
Yes, we are.
None of the letters listed above sent by Mr. McRae's counsel, see, I got that right that time, were ever returned undeliverable or with any indication that Mr. Curtis had moved. Go ahead.
So, every so often when you send a letter, I don't know if you've never had this happen or not, it might get bounced back to you with that little yellow strip on it that says a bunch of reasons why a letter can't get to you or couldn't get to where it was, and one of those is returned undeliverable, which means either this person didn't live there, or this person wasn't addressed to, or there just was no one there. If you send something through the post office and it doesn't bounce back to you for any reason whatsoever, it is normally assumed it was delivered there.
Yeah. The two items of certified mail both resulted in return receipts apparently being signed by Suzanne Curtis. ECF number 7 as Exhibit D. Mm-hmm. So they have this receipt. They have the receipt. Yeah. It's signed by Suzanne Curtis. Mm-hmm. And they are putting that in. They're submitting that to the court, so the court knows about it, right? because it's going to be, it's in this document. I'm assuming electronic court filing number 7, so it's in the 7th document.
Exhibit D.
Exhibit D on that document.
Yeah, it's basically directing the court to exactly where it is, so the court doesn't have to look through its entire file.
So,
because it's saving the court time, and the court's like that.
Courts like when you don't fuck around.
Pretty much.
It's kind of like Animal Crossing. Animal Crossing.
Yeah.
Animal Crossing. It's not the place where you want to fuck around.
Okay. I didn't expect an Animal Crossing reference today, I'll be honest.
Wait, you never heard that song?
Not that one specifically, no, but...
Boy, do I have a lot to send you. Just wait.
You probably do.
Just wait to hear Mario.
Okay.
Or I'm gonna send you the Zelda one later too. You're gonna love that one.
I love Zelda one.
It's about some guy's dick.
Okay, not so much.
So, Mr. Curtis never responded to any of the correspondence, either by mail or by email, to complain that his address was incorrect. Now, I assume that if you're getting letters and they're sent to your fucking mom, and your mom is signing off for this, your mom is most definitely going to tell you that, yo, you got some shit here, pick this up.
That would be the logical assumption.
I mean, would the courts make that assumption? Again, we don't know for sure, but let's guess. I would guess that the court isn't fucking stupid, and will also assume that, dude, it was signed by your mom. Get the fuck out of here. You were served.
Oh, I mean, including that along with the fact that, one, he admitted that he got served, and then 2, he sent in a thing to the court responding to its order before this. There's a lot of circumstantial evidence, quote unquote, that he was served personally, even though we don't even have to go that far for service here.
Yes. Let's see. Mr. Curtis clearly was receiving the various pleadings and correspondence in online Oh, here it goes. Here we go. Okay. In online interviews, Mr. Curtis referenced the lawsuit and indicated that he had not responded. McRae, AFF, I assume that stands for Affidavit 7?
Yep.
Okay. On February 4th, 2020, Mr. Curtis submitted a document to the court titled Compliance to the Order, in which Mr. Curtis purported to comply with the court's entry of partial judgment by default ECF number 18. Mr. Curtis would only have known to file such a response if he was getting copies of the various filings.
Yes.
Oh, yes. That's so good.
Yes.
Yes. God. Let's see. Oh, god damn it. Mortine Nielsen. I am a dwarf and I'm digging a hole. Diggy, diggy hole. Diggy, diggy hole. That's actually my ringtone. Can you believe that? You think I'm fucking lying?
No, I don't actually. I don't at all. I've watched enough of your channel to know that much.
So, defendant has filed a motion to set aside the default judgment, ECF number 19, and a motion to set aside default judgment revised, ECF number 20. So I guess that means that there was a fuck up in ECF number 19, so he had to fix that fuck up in ECF number 20.
Yeah, I don't exactly remember why. I think I know it was gone over before, but it doesn't even matter. You can file a motion, revise it. It's not a big deal.
Got it. Both include an affidavit from defendant stating that he moved on July 15, 2019 to an address in Charlotte. ECF number 19 at 9. ECF number 20 at 9. So that's because there was a revision of the same document, so they would both be at 9.
Yeah.
All right, this is the only...
There's a footnote there, Red. It's a very important footnote. I think you should go to it right now.
Oh, there's a footnote? Where the fuck do I find this footnote?
At the bottom of the page.
Oh, for fuck's sake. Okay, so let's go to the very bottom of the page, and that is the... Is that the I thing?
No. You've gone way...
I don't fucking know how to read legal doc. You're the lawyer here. You're supposed to be helping me with this shit.
Go back to page 4. It's at the bottom of page 4.
Go back to page 4.
There. See the little print at the bottom of the page?
Yes.
Yeah, that.
All right. The two documents referenced are one-page affidavits by defendant bearing what appears to be the exact same notary date and stamp. However, the second one, ECF number 20-9, appears to be an altered version of the first affidavit. It apparently was altered to show that delivery to the Providence Church whatever address was on August 30th, 2019, which is the date listed on the return receipt. Oh, fuck. I see what you're seeing.
Mm-hmm.
Oh, fuck. Okay, for the people in the back, OPT, you wanna take this?
So, he had the July 15th date, whatnot. If we go back a couple of pages here, the electronic tracking service, the U.S. Postal Service, had this delivered on August 30th to that address. Gee, he changed it to that date.
He changed the address on August 30th, which was also the date that it was signed for. So the change of address happened on the same day it was signed by Suzanne Curtis.
Well, no, he changed his address on the 15th. What I'm saying is he changed when the thing... Basically, he screwed up when it got sent there.
Uh-huh.
And it's one of those things. I'm like, dude, okay, you said before it was... You said you moved on July 2015. Whatever, that's fine. But your original thing basically had a wrong date on it. No, okay, again, changing a date on an affidavit is a weird thing to do. It's your affidavit, so okay, I guess.
So,
but with everything else, it's one of those things. It's like the death by 1,000 cuts.
Ah,
you know what I mean?
Yes.
It's that whole thing. It's like, okay, so maybe you just made a mistake on the date. Should you have just sworn out another affidavit? Yes, that's what you should have done. But okay, you changed a date on here, refiled it. Okay, not the biggest of deals, whatever. But
okay, so basically, there seems to be a contradiction with the date of move.
I think it was that second line there. So, court document states that the summons was sent to the yada yada on August 30th. That's the thing he changed.
Oh.
So that date said something else. What it is he basically got the date wrong on when the court document said this thing was summons and whatnot. Now, again, that's probably because he just wasn't paying attention, whatever. But the fact of the matter is...
Original said November 20th. He changed that date to August 30th using the same notary signature / stamp. It goes to gamesmanship, says Steve McRae.
What it looks like is that he whited it out and just used a typewriter and put it on there. I don't know what that means. I don't know if that's exactly what he did, but yes, it appears to have the same, if you look at the notary's signature and whatnot, and date stamp and everything, it looks the exact same.
Yeah.
So, I mean, it's almost clear that that's been amended. Now, again, is it a big deal? No. In and of itself, no. And the court would normally just ignore it, whatever. And it probably still will, but...
Yeah. Okay, so just to make
just
sure...
that extra little thing.
Yeah, so it's weird. Okay, so I might have misunderstood what that was referencing at first, so thank you very much, guys, for correcting me. And God's Auditor says, at Ritz Rhetoric, all he did was fuck up the date of the summons and then whited out the date and resubmitted it. He altered an affidavit after it was notarized.
Yes, and there's kind of the big thing.
Oh, okay, so I get it now, because if you're going to change something, you have to get it re-notarized. You can't reuse the same notary.
That's the proper way to do it.
Okay.
Now, as I said, is it going to would this be a big deal to anybody ever? No, the court would see this, be like, okay, it was just a typo, whatever. It's the same one. You shouldn't have done it that way, but I don't even care. This would not be a thing. But again, when you take everything else, it's just that little extra chip at credibility that's just going away.
So
Because now you've shown that you're willing to alter a document that's already been notarized. Again, pro se may not understand that that's a problem. Still.
yeah, so basically, we have a cumulative case of what could be called suspicious behavior. Is that fair to say?
Yeah, that would be a thing. Yeah.
Okay, sounds good. So we'll go with that. Doesn't mean anything big, but we'll say it's interesting, as Jeranism would say, after he got shown that the Earth was fucking round. Anyway, this is the only sworn evidence submitted by defendant, and that would be the only evidence that he actually moved.
Yeah, well, that's the only sworn evidence he's submitted at all.
Okay, so that's it. Okay, so the revised motion also includes several unsworn items of inadmissible hearsay. There are 2 documents titled Affidavit of Residence, purportedly signed by Suzanne Curtis, his mom, and Benjamin Potts, stating that defendant has lived in Charlotte since July 16th, 2019, ECF number 20 at 16 through 17. Neither of these purported affidavits are notarized.
That's a problem.
Okay, why is that a problem?
Well, that just means that these statements are not sworn, and normally when you submit an affidavit, if it's not sworn, basically not notarized, courts don't tend to want to actually use that, because that's not normally proper evidence before it.
Basically, they want to have the risk of perjury involved, just to spice things up.
Just to, something along those lines. So again, I'm not licensed in North Carolina. I don't know North Carolina law. I'm not practicing North Carolina law. This is not legal advice in any way, shape, or form. Just some practical advice of get your affidavits notarized.
None of this shit is legal advice. We said that at the very beginning. Don't at me, motherfucker.
Don't at me, bro.
I mean, my God, don't at me, because if you at me, I'll be like Mario.
There you go.
What up, bitch? I got a what up, bitch? What's inside the question box? It's my dick. My name is Mario. I'm more talent than pastrami. I'll take you by the peaches and give you the hot salami. Okay, I'm done. Anyway.
Thank you.
Okay, so let's see. Yeah, booze that are spooky. Must I be a raccoon to get inside? Okay, anyway. Okay, I'm done. Okay. So basically, neither of these purported affidavits are notarized. So does it actually count as an affidavit?
Again, normally unsworn affidavits are just not considered. Like a court normally can't consider an unsworn affidavit because again, it's this point. It's literally like you wrote a letter and said, here. It's like, well, that's not evidence I can consider.
No different than the hearsay statements on his supposed compliance to the order.
Yeah, that's another thing that would just be like, yeah, I can't really use these for like credible evidence.
Yeah. Defendant also attached a copy of purported rental agreement for the residence in Charlotte, ECF number 20 at 11 through 12, and credit card statement showing the Charlotte address, ID at 13 through 14. And
so ID, just in case you're wondering, it means the same thing I just cited before.
Oh, okay. And a 1099 form showing the Charlotte address, ID at 15. Fucking legalese.
Yeah.
And finally, defendant attached what he calls a transcript of a YouTube video where
I saw that.
Where he includes a link to an obviously doctored 54-second snippet of a video. ID at 10. None of the attachments to defendant's motion, even the unsworn statement and hearsay, provide any evidence that defendant failed to receive notice of the lawsuit.
Right. So we're basically like, yeah, all this evidence that you submitted, even pretending for a moment that it was admissible, doesn't actually prove anything.
So it's more gamesmanship, you think?
It's that, or it's the pro se mistake of attaching everything you think is actually going to work to a document, and only to find out that none of this is actually relevant to the issue at hand. Yeah, I had a lot of my own clients had issues figuring that out. It's okay.
Oh wow, this is funny. Oh wait, there's Oh yeah, this is what we referenced last time, right? The this little eye thing.
Yes.
Okay,
Yes.
so we already referenced that, so we'll go
3. Yeah, we're at 3 now.
No, 3 eyes.
Okay. Yes.
Argument. Oh wait, you can actually hear arguments now.
Yeah. That was just a summary.
Oh, fucking bitchin'.
Yeah.
Okay, so let's see. Motion to set aside are in the discretion of the trial court and will not be overturned except for abuse of discretion.
So what the lawyer is telling the court here is just FYI, here's your standard of review on appeal. So if you decide to deny this motion to set aside, the standard on appeal is going to be an abuse of discretion. That is a very, very high standard for an appellate. For an appellant, the person appealing, to meet. It's basically trying to convince the Court of Appeals that the trial court acted in a manner that was arbitrary, capricious, or just completely there's another word I'm missing. Just in without the color of law, basically, without legal anything. Just the court randomly decided to do this.
Oh man, that was something. So let's see. Defendant, which Kyle, asserts that the partial judgment by default should be set aside pursuant to Rule 60B4, this is going to come up a lot, of the North Carolina Rules of Civil Procedure. Motions for relief under Rule 16B are within the sound discretion of the trial court and will not be overturned on appeal unless the trial court is found to have abused its discretion. Estate of Teal v. Darby, 129 North Carolina, App 604, 607, 1998. Holy shit.
That's a citation. The 129 NC app, that's normally means the North Carolina Appellate Reporter. 604 is the way us lawyers would find that case. And then the 607 after that is the pinpoint page number, which means on page 607 of this reporter is where you're going to find this exact thing.
Oh, I see. So not only are they stating it, they're going to this previous case for a bit of street cred.
Yeah, because we have the great thing we call stare decisis in the law, which is a really cool Latin phrase because I like using Latin because I'm a lawyer. So, yeah, basically what it is this has been decided before. It should be decided the same way again. And lots of times you'll get from the courts of appeals and the Supreme Courts of different states, this is what we call case law, the way the courts have interpreted law in the past and whatnot. And, yeah, it's our legal precedent, basically.
Yeah, legal precedent. Okay, so that street cred has been entered, so thank you, Steve's lawyer. Under 60B4... a judgment may be set aside when it is void. Defendant contends the judgment here is void because he was not properly served with the summons and complaint as set forth below. Service was proper and the judgment is not void. B. Service is presumed to be proper because plaintiff served defendant by certified mail and filed an affidavit as required by the North Carolina Rules of Civil Procedure. So basically this means that, McRae did everything right, y'all.
Mm-hmm.
And also, the McRae doing everything right is presumed.
Yeah.
That's an epic rule.
It's presumed to be proper, because the plaintiff certified by certified mail. Yeah. So basically, it's presumed proper service, and it's on Kyle to prove it was not.
So, what would he have to do? Say, listen, I was in a coma... because
if he could actually produce, again, hypothetically speaking, if someone in this situation could actually produce hospital records to show that I was literally either number one, in a mental ward that, I was in an actual invalid for the last 6 months in a coma or, in an actual body cast and couldn't move any place. Okay. Maybe you might have a thing there.
So someone's going to forge some records of Kyle Curtis being taken to the Happy House and in a straitjacket in a sponge room where he's just rocking back and forth saying, I am 95%. I am 95%.
Yeah, something beyond his control. Something along those lines.
Well, considering that he was having all this time in the world to talk about the case live on air... he kind of screwed the pooch on that one. He obviously wasn't in a coma. He obviously wasn't in the happy house. So what the fuck?
Yeah.
Fuck. He was on multiple streams talking about this shit.
Yeah. Yeah, I don't know why you would sit there and talk about a lawsuit and then claim you weren't served with it.
I mean, holy fuck. It's like, all right.
Mm-hmm.
All right, so let's see. Under Rule 4J1A of the North Carolina Rules of Civil Procedure, a natural person, such as defendant, may be served by leaving copies of the summons and complaint at the defendant's dwelling, house, or usual place of abode, with some person of suitable age and discretion then residing therein. Service may also be obtained by mailing a copy of the summons and complaint, registered or certified mail, return receipt requested, addressed to the party to be served, and delivering to the address. NCRCP, sounds like a rap group, 4J1C.
I'm assuming that is North Carolina Rules of Civil Procedure. Yeah, it's got to be it.
Oh, so it is a rap group.
Yes.
Okay, cool. Very weird reference, Steve. Tell your lawyer that we need to have a chit chat. No, seriously, Kyle's lawyer, call me, maybe.
I'm over in North Carolina in a business suit. Heck yeah, man. I legitimately know the firm I'm calling, and for some odd reason, I'm ever in a suit in North Carolina.
When service is obtained by certified mail, the plaintiff must file I think that's supposed to be an affidavit. Must file an affidavit stating that a copy of the summons and complaint were delivered to the post office for service by certified mail, return receipt requested, that the copy was in fact received as evidenced by the return receipt, and attach the original copy of the return receipt. NC Gen Sat weird fucking fucked up double S thing 1-75.10A for fucking Christ, guys.
Yeah, I know, it's lawyer stuff.
You lawyers are a different group.
Yeah.
You're not normal. You're not fucking right in the head, bro.
Yeah, you know.
Why can't
I wasn't right in the head before I became a lawyer. I think that might be why.
Why can't you just sing about Mario Penis like the rest of us? The affidavit raises the presumption set forth in Rule 4J22 that the person who receives the mail or delivery and signed the receipt was an agent of the addressee authorized by appointment or by law to be, next page, served or to accept service of process, or was a person of suitable age and discretion residing in the addressee's dwelling, house, or usual place of abode. The presumption does not require the signature of the actual addressee. See Moore Street Cred, Grainville Med, CTR v. Tipton, 160 NC, App 484491 2003. Moore Street Cred.
Yep. More precedent.
I'm assuming that Kyle's mother is of suitable age.
I mean, I would hope so.
Otherwise, there's some. Otherwise, dude, your family tree is a circle.
Yeah.
Here, plaintiffs, let's see. Oh, wait, the presumption is an identity, blah, blah, blah. Yeah, we read that shit. Here, plaintiffs served the summons and complaint on defendant by certified mail at the address defendant had regularly used. So there's actually, a history of this address. So it's not just some random backwatered address that was pulled out of thin air. This was an actual address that was used by Curtis.
Not only that, but if you remember back from the recitation of the facts earlier, he actually held it out as his address for show emails and to other people. So, there's clearly evidence that he was using that at some point.
Yeah. Plaintiff never received any return mail showing that the address was incorrect, and defendant never took action to correct his address on the numerous items of correspondence sent to him at that address and by email. So basically, this shows that Kyle wasn't doing his due diligence.
That is a polite way of putting it, yes.
Oh, really? How would you put it?
I would put it exactly like that, because I'm a polite person.
One of these days, I'm going to get you to sing about Mario Penis.
Yeah, I don't think that's gonna happen. Just saying.
Why not? Is that a challenge?
Yes.
Note to self. Okay. Okay, Google. Remind me to accept the challenge in 1 hour.
Sure, but first you'll have to unlock your phone.
Ah, son of a bitch.
Sure, I'll remind you at 11:42 p.m.
It's on.
Okay.
We're having quality time together. This is quality
Absolutely.
time. Absolutely. Okay, so let's see. Airplane serves summons, blah, 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 by addressing the email. The summons and complaint were signed for by a person at the address. Plaintiff filed the required affidavit and attached the original return receipt. Under these facts, proper service on defendant is presumed. Yeah. So that's what we lawyers like to call a slam fucking dunk.
Well, no, not necessarily. What we like when we say presumed, that means we have that means the plaintiff or Steve or Kyle's counsel at this point, we have the presumption. It's on Kyle to rebut it.
So in other words, a slam fucking dunk because Kyle ain't got shit.
Yes, something like that. Yes.
All right, perfect. Yes. So, hey, listen. Whenever I make a suggestion, just say that I'm right, okay?
Oh, okay, sure, no problem.
Yeah, you're the lawyer here.
Uh-huh. I do what my clients tell me to do. Just saying.
Yo, if you
by the way,
if you want me to accept this case, you'll 86 your shit here, and definitely here.
Right.
Okay, I need you to follow this rule, Mr. Curtis. Shut the fuck up. If you hear if you hear anything online, shut the fuck up. You hear anything on Twitter, what do? You shut the fuck up there too.
Mm-hmm.
If someone says hi to you, you still shut the fuck up because we ain't taking no risks. Shut the fuck up.
Yeah. No.
The presumption of service is rebuttable. Oh,
Yep.
so that means it can be debunked.
Yep. It can be rebutted.
All right. To rebut the presumption, a defendant must present evidence that service of process failed to accomplish its goal of providing defendant with notice of the suit rather than simply questioning the identity, role, or authority of the person who signed for the delivery of the summons.
Which, that is telling me that it doesn't matter who signed for it. It just matters if the notice actually gave you notice.
So it was to... So the goal here is you need to prove that it did not give you notice.
Mm-hmm.
That's a pretty heavy burden of proof.
It is, as a matter of fact.
Interesting. So he has to show that he was not properly served.
Correct, and had no notice of the actual lawsuit.
Oh, I had to. What I did was I in the original papers that I was served.
I'm sorry. What was that? One more time, Kyle. Please repeat that.
Papers that I was served.
One more time. I don't think I heard you.
Papers that I was served. Papers that I was served. Papers that I was served. Papers that I was served.
Thank you, Kyle. Appreciate it. We have fun with this shit.
I absolutely do. That's great.
All right. Courts. So let's see. Courts do not countenance, I think the word is, gamesmanship by parties attempting to avoid legal process. A lawsuit is not a children's game, but a serious effort on the part of adult human beings to administer justice. God damn.
So the greatest thing is that appears to actually come from a case. I saw that line before. I'm like, man, that is a great line by this guy, by the lawyer here. And I'm like, wait, it's in quotations. So it's from that
It's an actual quote.
It's a quote from that, probably from that Granville Med case, which I'm like, wait, so number one, the lawyer found that line, which is amazing. And number two, a court has said this before.
Holy shit. It's like, so basically it's like, Your Honor, I submit that the defendant, Kyle Curtis, is acting like a fucking child.
Pretty much.
Uh-huh. And then
I want to pull this case up now.
and then the judge will be like, excellent point. Gavel.
Something like that.
That's a meme for those of you who don't know. Here, the defendant has treated this lawsuit like a children's game rather than as a serious effort to administer justice. Defendant has been sent multiple notices by mail and email starting in July 2019 and has failed to respond to any of them. In the meantime, defendant has appeared in YouTube chats making it clear that he was fully aware of this proceeding. Oh, here we go. Here it comes, guys. This is where it gets good. It's really good. Oh yeah, that's right. Read it. Read that fucking court filing. God damn you, shit. Got a fucking legal boner right now. Oh God, yes. I'm sorry. Excuse me.
Mm-hmm.
Aren't you glad you came onto my stream, by the way?
I am, actually. I'm very happy to be here.
Good. Defendant apparently never filed a change of address with the United States Post Office, which, by the way, adults do that, so yeah, fucking childish shit.
Normally, yes.
And defendant does nothing in his affidavit to explain why documents served at the other address and signed for by a relative were not delivered to him. So basically, does your mom hate you? Are you guys not on speaking terms?
It would have to be something where you would have to be able to show that she got these documents, signed for them, and then literally threw them in the fireplace.
Yeah, and that's a pretty heavy burden of proof.
And that sounds completely ridiculous too, but you know.
Mm-hmm. In fact, defendant's affidavit does not claim. Actually, before I read this, wow, I hate my son so much that I'm going to go ahead and throw this shit in the fireplace so that he can go ahead and get screwed over by some dude he met on the internet.
Right.
Seems legit, bro. I just want to throw that out there. In fact, defendant's affidavit does not claim that he did not receive any notice of the lawsuit. He merely claims it was served on a previous address. Nothing that defendant's attempt to rebut the presumption of service... Noting that defendant's attempt to rebut the presumption of service failed to allege that he did not receive the summons or notice of the lawsuit. Even the purported affidavit signed by Suzanne Curtis does not say that the defendant did not receive notice. That seems like a pretty big detail to omit.
You would think that if you're submitting an affidavit in an attempt to say you weren't served, that you would actually have the affidavit say that this wasn't served.
Holy shit. That's ECF number 20 at 16. Wow. Yeah, so basically they're what they signed, their affidavits, it doesn't say that Kyle didn't get notice.
Yeah.
It doesn't say that at all. Like, why omit that? Why fucking omit that?
Because it wasn't true.
Oh.
I don't know.
You think a little bit of honesty was seeping through there?
I'm just thinking out loud here.
Never say never?
Yeah.
Yeah, never say never. Especially to the fact of you singing about Mario's penis. Anyway, to see the extent of defendant's gamesmanship, there's that word, gamesmanship, one need look no further than the snippet of YouTube video that defendant linked. That small piece of video comes from a YouTube show that Mr. McRae participated in on September 23rd, 2019, about 3 weeks after the summons and complaint were served. That podcast is over 2 hours long and covers a wide variety of topics. And ID. Relevant here, the podcast discusses allegations by others that Mr. McRae had doxed defendant by filing the summons and complaint with the business court. Other had alleged that defendant had no longer lived at that address. Mr. McRae's take on the subject was that A, he had not doxed defendant by initiating a lawsuit or following the rules of civil procedure. Yeah, no shit.
Mm-hmm.
Sometimes you wonder why this shit needs to be typed. And B, if the address was wrong, as defendant claimed, it could not be doxing.
I mean, I actually remember that.
It is obvious from this discussion that defendant knew about the complaint since he was aggravated at being doxed.
Yeah. God, I didn't even think of that. Oh my God, wow. I didn't even put that together. Wow. Oh, jeez.
He knew about the complaint because he complained about being doxxed on the stream when they were talking about it.
Okay. Yeah. Oh, wow. I did not even think of that.
Holy shit.
Okay. Wow. Yeah. Okay. Yeah. That's.
Wow. Okay. Hang on one second. Okay. Okay. I'm just gonna walk around a bit. Okay, and relax. Okay. Wow.
That is such a good freaking point right there. Well done.
Well done. Good
well
job.
Done, sir.
Good job.
Well done.
Damn. Wow.
Good on you, Mr. Myers. Well done. Jeez.
Holy shit. That's amazing.
That is insane.
However,
That's great.
However, defendant did not respond by providing his correct address or acting to quash service of process. Instead, he ignored all correspondence sent to him and refused to appear until long after his default was entered. Such behavior is not rewarded by courts in North Carolina. See Granville, basically more street cred.
Yep.
Holy shit. Conclusion. As stated above, plaintiff is entitled to the presumption of service, and defendant has failed to rebut that presumption. Therefore, defendant's Rule 60B motion to set aside the judgment should be denied. Respectfully submitted this the 12th day of February 2020. So beautiful.
This is so. Just FYI, I looked up that children's game line quote from the one case. Not only is it there, it's actually that case is actually quoting it from a North Carolina Supreme Court case.
Oh, wow. So that's the children's game quote.
Yes.
Holy shit. That is absolutely amazing.
Mm-hmm.
I love everything about this. There is literally nothing I hate.
No, there's not much to say about it. It says everything it needs to. It's well organized.
Yeah, let's see what we have. This is the next document is literally just a rehashing of this. Actually, no, it's not a rehash. Oh, this is a good one. Okay, so we're gonna do this one next because yeah, it's great.
This is the briefing support. Okay.
All right, let's see. So for this one, it's plaintiff Steve McRae through his undersigned counsel and pursuant to North Carolina Gen Sap blah 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 legalese talk submits this brief in support of motion for order to show cause, requesting that the court order defendant to appear before the court and show cause as to whether he should be held in civil contempt for failure to comply with this court's entry of partial judgment by default. Big oof.
Yeah.
Since you're of the legal mindset, maybe.
Yeah.
Can you please,
allegedly?
Can you please tell us what that means?
Well, I mean, so what we're looking at right here is actually a brief in support. So this is the legal argument as to why they're saying the court should hold Kyle or basically enter an order for Kyle to show cause why he shouldn't be in contempt. The motion is actually a separate document.
You said that word. Can you please repeat it? The one starting with a C.
Contempt.
Hang on, one second. Can you say it again, please?
Contempt.
Okay, keep going.
Contempt.
Almost there. One more time.
Contempt.
Okay, I'm done. Okay.
As I said, I think my internet career is. I'm never topping this. This is over. This is great.
Okay. Okay. Sometimes I ask myself, what the fuck is wrong with me?
I ask myself that every day, actually.
Why did I show up to this stream? Why did I order pizza with pineapple on it?
I know.
Why am I soon going to be singing about Mario's penises?
I don't know why you're going to be doing that one.
Notice I said penises, as in more than one.
Yeah.
I bet you didn't know that about Mario.
Yeah.
Pursuant to North Carolina Gen Stat, blah, 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 a person may be held in civil contempt when 4 conditions are met. 1. The order violated remains in force. 2. The purpose of the order may still be served if the alleged contemptor complies with the order. Thank you. The alleged contemptor violation of the order is willful, and 4, the alleged contemptor it is able to comply with the order. So let's start with the first one. The order violated remains in force.
So it's a valid order that is still presently, like it's valid order, basically.
Okay, so let's see. So basically, we have an order that has been violated, but that's still enforceable.
Yeah, that's still an active order.
Okay, you violated an active order as number 1. Number 2, the purpose of the order may still be served if the alleged contemptor complies with the order. So that one is saying what?
Basically, Kyle can still, like, the purpose of the order, which was the whole, give everything over, that could still be done if Kyle complies with it.
Got it. The alleged contemptor's violation of the order is willful. Yeah, we fucking know that. Twitter, the Twitter fucking handle. Now it's like, oh, I'm just going to delete this despite the fact I was ordered to give it back to Steve McRae. Let's see. And 4, the alleged contemptor is able to comply with the order. Well, we know he's able to. He's just fucking refusing to do it and deciding to, go for gamesmanship.
You wouldn't be able to hold someone in contempt for something they literally could not do.
Yeah. So, hey, I'm gonna hold you in contempt for not being able to fly with pieces of cardboard duct taped to your arms.
Yeah, see that? Yeah, that'd be a thing.
Yeah, so that wouldn't fly. See what I did there?
Yes, I did.
I'm writing that one down.
You should, absolutely.
Oh, fuck yeah. Okay, perfect. Anyway, I make no apologies. Fuck off.
No, you don't. That's fine.
And so basically, he has the ability to turn over the channel. He has the ability to turn over the Discord and the fucking Twitter. But instead, he decided to delete the Twitter, not turn over the channel, and basically just present hearsay summaries of the supposed financials.
Yeah, I don't even know what the heck that was. He tried to submit to.
That was him pulling shit out of his ass. That was him pulling shit right out of his ass.
More than likely.
Yeah. So let's see. And oh yeah, I did this thing and I put the Non-Sequitur show 20K in the hole. Cool.
Yeah.
North Carolina Gen Stat 5A-23A. Such order may be issued on the affidavit of one with an interest in enforcing the other, and a finding by the presiding judicial official. That there is probable cause to believe the alleged contemptor should be held in contempt, and then more street cred. Once it is determined that probable cause exists, the burden shifts to the alleged contemptor to show that he should not be held in contempt, that he lacks the means to comply, or that his non-compliance was not willful. Yeah, good luck proving that shit. Here, plaintiff relies on the sworn affidavit of Stephen McRae, filed contemporaneously herein, to show probable cause to hold defendant in contempt. As shown in affidavit, Mr. Curtis has failed and refused to comply with the partial judgment by default, ECF number 17. Moreover, he has openly defied the judgment by willfully deleting the Non-Sequitur Show Twitter account. There it is. There it is, because that is destruction of digital property as far as the court is concerned.
More than likely, yeah, that is when the court tells you to turn something over, you don't just delete it and be like, nope, you can restart it. It's not what the court told you to do.
I was ordered to do this thing, so I'm just going to, and that thing was to turn over this thing, so instead I'm going to destroy it.
Yeah, I was ordered to turn over this car back to the dealership because I didn't pay for it. So instead, I took it to the junkyard and had it like smashed into a flat iron piece. Now,
it's now a skillet.
Yeah, it doesn't work that way.
Finally, defendants submitted documents to the court showing that all the revenues earned by the Non-Sequitur Show are missing, presumably showing the defendants' willful absconded,
willfully absconded with the funds, aka he took the funds and run.
Oh, he took the money and he fucking ran.
Mm-hmm.
Decided to blow it on fucking Suits, I guess. That's going to be a joke that gets referenced later. ECF number 18 at 20. Wherefore, for the reasons set forth above, plaintiff requests that the court find that there is probable cause that the defendant has violated the judgment and order him to show cause as to why he should not be held in civil contempt unless and until he complies with the judgment. Respectfully submitted this the 12th day of February 2020. And notice how it doesn't say Scott Brown.
I got that. I love a good wherefore line.
So, Mr. Lawyer, now that we have read the documentation, can you please give me your overall opinion about this? What are Kyle's chances of walking away with some sort of victory? What are Steve's chances with walking out with some sort of victory? Again, not legal advice,
right? Not
at all. But just give me your opinion as someone who has dabbled with a bit of legalese.
I mean, obviously, without knowing North Carolina law, I can't say too much. But I mean, I think Steve's in a really good spot. His lawyer is clearly very competent, and I mean that in a very good way. He's these are.
I mean, he knows what the fuck he's talking about.
Shockingly, yes. Yeah, I would think that it's going to be difficult for Kyle to fight these unless somehow he finds some evidence to support his claim and I don't know where that would come from, but
So basically, good luck with that.
Yeah, pretty much good luck with that. Yeah.
All right, well, that is pretty much our show. Thank you all for watching, and thanks to everyone who supported. I am going to start bringing this off air, but before we do, we are going to do our due diligence, and we are going to read some super chats. So, Mr. OPT, if you will remain for that, and then we will go ahead and call it a night. Does that sound like a plan?
Sure.
All right, good. Then we'll get to work on having you sing about Mario Penis. Oh yeah, you thought I forgot about that.
No, I didn't think you forgot about it.
I have a reminder on my phone.
I know you do.
One of these it's just gonna pop up and be like, oh yeah, I remember that. This is great. I love our community. I love what we do here. It's great. We have fun, even though this is objectively a shitty situation.
Yeah. I mean, the worst thing of this is we're making light of something that really sucks.
Yes. At this point, you can't help but laugh at it every now and then because it really sucks.
Well,
it should not have taken this long.
As a criminal defense attorney, though, you get jaded to a lot of, real life situations.
Be like, oh, this here's a lawsuit that's going to take a fucking year to get over.
I mean, yeah, it just turns into, oh, this is, the legal system here, instead of, these facts are important to people,
So, for $10, Ilya Moon says, D fucking Nide. For $2, we have $2 from Kyle's disappointed mom.
Oh.
Oh, God. Anyone get the number of the bus I'm under? Oh my God. Ilya Moon for $10 again. Hi, y'all. Kyle sucks. Okay, yeah.
Simple.
I mean, yeah, short, sweet, simple, to the point, you know. There it is, right there. Ilya Moon. Hi, all. Kyle sucks. That was the one for $10, so thank you. Failed at engineering for $5 New Zealand. So Kyle responded to the filing/notice, quoted from them, and then said he had not received those. Really? Thanks for your super chat. Mortine Nielsen for 45 dick dollars. Hey, Reds. I am a dwarf and I'm digging a hole. Diggy, diggy hole. Diggy, diggy hole. That's actually a song. OP, I'm going to send you so much shit.
Okay. I'll wait. I'll look forward to it.
Oh, God. It's great. Okay. All right. I might be mispronouncing this name, but oh well. Anti-Hirvensalo. I think that's how you pronounce it. I apologize if I fucked it up. I promised for somebody to donate to your camera gear, but slept through your fundraiser. Sad face. Because fork your non-European time zones. Here you go for €10. Thank you so much. I'll be using all the super chats that have been gathered from tonight to buy batteries, controllers, and shit like that that's needed. Because, as you know, I need power. Think I might, you know, shit runs on electricity.
Normally does.
So apparently, I need to bring the electricity with me. And
oh, you mean the flat earthers haven't figured out how to make energy just kind of appear from like nothing?
I mean, I wish that would make my life fucking easy. Just bring a free energy device with me, then I wouldn't have to carry around these electricity characters, also known as batteries.
Right. Might actually make them useful for once too. I'm sorry. What was that?
Dim Sum Nim Sum for $2 Canada. Does that mean Kyle's mom has got it going on? We're just going to skip that. Thanks for your $2, man. Failed at engineering for $5 New Zealand. But by this time, if Kyle doesn't realize his advisors are effing with him, then he gets my nomination for Dumb Fuck of the Year for 2020. And the last super chat we're going to read is failed at engineering, $2 New Zealand. Hashtag send Kyle to jail. So guys, thank you very much for watching. Thank you very much for being here. Thank you for having such low standards that you decided to stick with us.
No problem. Thanks for having me, man. This is fun.
So, OPT, thank you so much for your time. So we're going to go ahead and call it a night. Thank you so much for watching. And OPT, say what you got to say and get the fuck out.
Thanks for having me again. And I'm going to probably be streaming video games on my Twitch channel at some point. But have a good night, everybody.
All right. Peace. All right, guys. That is it. And we are out. Have a good night, people. Goodbye.
Hold on a sec. Reds, hold on.
Oh, fuck. We're still live. What?
Oh, we're live?
Yeah.
No, I thought we were off. My bad. No, I'm good.
Are you sure?
Yeah.
Are you sure you don't want to sing about the penis?
Pretty sure.
Okay, repeat after me. What up, bitch? I got a one up, bitch. What's inside the question box? It's my dick. And you're no fun. All right. Have a good one, people. Good night.